Just who knew about the scandal that was going on between the Los Angeles Police Department, the Los Angeles County District Attorney's Office, and the Compton Court Building? Today, in this video, we're going to be discussing exactly who knew what and who knows what and what are they trying to hide. Jamal, known as Eddie Walker, another video. If you haven't already, please subscribe to my channel. And most important, please help me to get this message out by liking this video. Today, I will be sharing more documents with you of how the whole system has been set up, basically to walk you hand in hand all the way to your ruin while destroying paperwork in the process, leaving innocent people as victims and portrayed as criminals to society when they have absolutely done nothing. In February of 1992, I was sent from Compton Court Building down at LA County Jail up to Wasco State Prison. When I got there, there was no paperwork. I spent 2 weeks in solitary confinement before they can receive me into the prison legally. This was my identification card. You can see that. So, for anybody who think that this story isn't real and that I didn't go to jail, this was my number, H25031. When the paperwork finally did get to CDC, it was strange that, as I pointed out in the last video on my live scan, it shows that Linda Bushling filed this paperwork to the Department of Justice, to the Department of Corrections, while also having the transcript of all of the court proceedings transcribed into a transcript and mailed to all of the appellate attorneys. Now, it's set up that the appellate courts issue attorneys for people who have been convicted so that they can appeal the conviction. If you can already see from that where this is going, that's where I'm going to show you they did with this whole charade. This is a copy of the appeal that was sent to the appellate court. You will see that on the document it states, appeal from the judgment of the Superior Court of Los Angeles County, Robert L. Lafont, judge. So he's notified that I appealed this. Mark Allen Hart, under appointment by the Court of Appeal for defendant and appellant Walker. So they gave me an attorney to represent issues that they knew automatically they were going to deny. How can I say that? Because this attorney, for one, never looked to see if those charges were legit. Attorneys go through all of your paperwork looking for the smallest thing that they can do normally to help you once you've been convicted. If they feel that you've been given too much time, they'll go and argue that you should have had factors that reduce the amount of time that you had. So they knew all about this. Also, a copy of this was sent to Daniel Lundgren, the Attorney General, and there was also a Deputy Attorney General named Richard L. Walker. Briefly, what they do is they take several issues that they point out that they think that you can most likely receive some type of what we call action on to get your appeal granted, and they'll go into your record, take portions of it out. They would argue those arguments in what is called a brief, and your record after that is basically useless for anything, because after those issues have been argued into a court, there's nothing else you can bring up. So I was quickly hurried through the state courts. What was shocking is when it got to the federal courts. You once you finish with the state courts, you can raise any issues in the state court. In the federal court, you can only argue issues of a violation of a constitutional right. If the document of live scan shows that these material had never been even filed or known to the state of California and that there was no arrest, that should have been the main argument of a violation of a federal constitutional right. It should have been a state argument. But Mark Allen Hart did not argue that, even though he knew that there were no documents, such as a police report, that gave him anything to go on regarding the case. To make a long story short regarding those issues, it supposedly happened at, like I said, at Quick and Split Hamburger Stand. No employees were ever interviewed. There was no evidence whatsoever that came from that burger stand that was in the paperwork that he should have been able to refer to have an argument about either identification or the circumstances of the crime. So I was walked through the state courts very quick, and my case ended up in the federal court. This is a copy of the federal writ right here. In this federal writ, it's screened by a magistrate judge. Now, this magistrate judge, he also knew that there were no documents on this case because the federal court didn't have a record of the crime. There was no arrest. There was no fingerprints taken. And when you're arrested, a copy goes to the federal government. The federal government had nothing on me. The federal government did not even have a copy of the transcript because after the transcript was given to my attorney, they destroyed all of the originals. So they had nothing to go on. Once this federal judge put his name on that paperwork and he made a recommendation, his fate was sealed. And like Judge LaFont, he left the bench right after. Once this magistrate made this recommendation, he left the bench as well. But look at what he did. This is a copy of his writ. Right? Denying the habeas corpus. It says, Plaintiff Appellant Eddie Walker appeals from the ruling of the federal judge Edward Raffiti dated February 12, 1998, wherein he adopted the recommendation of Magistrate Judge R.J. Groh, thereby denying petition plaintiff appellant's motion for issuance of writ of habeas corpus. But show you how bad this was. It was denied with prejudice, meaning don't ever bring this back into the court again. It's not to be heard anymore. And they also ordered that, like the state court, it not be published. So you're not supposed to be able to even look it up. Pay close attention to what I'm going to show you in what they state in this petition right here. I'll let you read it for yourself first. Can you see that? If you can stop your computer, possibly screenshot it for yourself. And I'm going to read my highlighted parts to you. Petitioner, a state prisoner, was convicted of 2 counts of attempted murder. In footnote 1, the first 2 words, it says, the information charged 6 counts of attempted murder. The information. There's no way, no place, nowhere in the documentation with the courts where I was charged with 6 counts of attempted murder, other than the paperwork that was doctored by Gary Aspinall. If you remember, I showed you in the minute orders that I was originally charged with 3 counts of attempted murder. There was a guy named Henderson Glover whose attorney came to court and said that Gary Aspinall was illegally contacting him at Juvenile Hall Los Padrinos, to get him to come and go along with the prosecution of me in this case. This took place before 7/12. I think it was on 5/9 that took place, and I showed it to you in the minute orders. If you can, please go back and check that for me. It also says petitioner was charged with the attempted murders of Bobby Taylor and Joe King in counts 4 and 5, and found guilty on both counts. What their version of the story is, they say on December 29th, 1990, about 9 o'clock to 9:30 p.m., Bobby Taylor and Joe King were at a service window at a fast food restaurant located on 91st and Central Avenue in Los Angeles. A car drove through the drive-through lane, and someone in the car said, "What's up, cuz?" Shots were then fired from the right front seat of the car, and Mr. Taylor was hit in the buttocks and King in the elbow. Both were hospitalized. The jury convicted petitioner of the attempted murders of Mr. Taylor and King. The jury did not reach a verdict against the petitioner as to the other counts, thereby caused the jury to deadlock 11-1 on those counts. Mr. Taylor's testimony was uploaded onto video on YouTube. I don't want to read it here for the sake of time, but to show you the statement of the court. It says that the court must examine the evidence in light most favorable to the prosecution, and must presume the trier of facts resolved conflicting evidence in favor of the prosecution. So even though, like I showed you on the front page of this, where they referred to the information that was basically under the table, fabricated stuff going on between the police officer and the prosecutor, they had on their desk, they referred to those 6 counts, showing you that they were in the know about this. I had no chance whatsoever in a federal court. After this denial, I hired a private attorney to find a way to try to get me back into the court. This document here shows that filing and when it took place. Now let me show you what was the response of the federal court. This is a letter that attorney filed. If you can't see that underlined part, take a good look at it. All right. In this, he says, he filed this petition, and they didn't file it. They tried to throw it away. So he says, "Dear Brother Jamal," referring to me, "as promised, I went to the federal court and checked their computer database. I also requested and received a printout of all the transactions they have a list of to date. The clerk of the court is correct. There is no record of the filing of the motion for reconsideration. I contacted the clerk of the Ninth Circuit Court a few minutes ago," and is the number. He says, "He informed me that although rare, the motion could have gotten mislaid." At the end of the letter, he said, "Again, I believe the Ninth Circuit either was playing games or made a mistake." Also in 1998, as I was appealing this, the LAPD scandal down at Rampart was starting to get very known. And I started writing around to almost all the city officials. I wrote to, what's his name? I wrote to the district attorney's office. I wrote to Steve Cooley. Was it Mike Antonovich? I wrote Maxine Waters. I wrote everybody that you can think of trying to get an investigation number. I was given one. No one ever responded to it. It took me almost a year just to get somebody to answer why nobody was, coming to interview me. Well, in, was it 2000, August the 2nd, I had two officers to come up to Lancaster State Prison. You can check their law records. Two LAPD officers, one sergeant and a regular officer, came to interview me. When they came in, they had a broken tape recorder and were pretending as if they were recording the conversation. They didn't have no documentation regarding the shooting of Bobby Taylor or Joseph King. Instead, they brought paperwork regarding the 325 shooting that had been dismissed. Um, this is an article from Hip Hop Magazine that came out. This article was in 2007. Well, there was an investigation done into the death of Biggie Smalls, because a couple of the officers that were involved with this were Pyrus from Compton. Now, let's try to put all this together. The Compton police were so corrupt at that time that they were basically dismantled and the sheriff took over. You don't think that they had any business dealings with the district attorney's office in Compton Court back then? Of course they did. In this article, it says there was an officer named Poole who was trying to blow the whistle that Bernard Parks was covering up some of the allegations that he was making, and he was a police officer. He says Poole claimed that the LAPD chief Parks refused to investigate their claims of Mac's involvement, suppressing their 40-page report and instructing investigators not to pursue their inquiry. By August 12, 1997, when former Deputy Police Chief Bernard C. Parks was sworn in as LA Chief of Police, Biggs' death had already began exposing the rest of the country to the rampant corruption of Rampart and its gangster police problem. So officers like Poole and Tyndall were peeling away the elaborate layers of illegal activities. Parks was likely thinking of ways to protect his job. The reason I'm bringing this up about Parks is because Parks was the one who personally wrote to me in prison, sending me my investigation number, informing me that two LAPD officers would be coming to interview me regarding this matter. It says, in May 1998, Chief Parks finally established an investigative task force deemed the Rampart Corruption Task Force. Their primary focus was the prosecution of Rafael Perez. Meanwhile, the investigation of one of the most high-profile murders in Los Angeles was taking a back seat to the LAPD's internal problems. It was obvious that they weren't going to solve anything anytime soon. And you want me to tell you how I know that this is telling the truth? Is because after I was interviewed by those two officers on August the 2nd of 2000, they told me 30 days later that they would contact me and let me know what the results were. Well, 2 months later, I didn't hear anything. And when I called and found out, they told me that there was a recommendation by the Los Angeles Police Department made on July the 31st to close the investigation, 2 days before they had even come to speak to me. A record of the filing, I was told by Gwendolyn Polak, was made at the Ronald Reagan Federal Building in downtown Los Angeles. I would not be surprised if it, like everything related to case number TA005544, has been destroyed. So if anyone who's curious or intrigued about finding out about this LAPD investigation cover-up, try contacting the Ronald Reagan Federal Building and ask about the investigation involving the two officers on August the 2nd, 2000 at Lancaster State Prison. That will give you some answers. Moving forward to 2007, I appeared before the parole board for my initial parole hearing. 2007, now that made it 17 years since the day I had been taken off the streets. And when I made it to the parole board, just like the two officers who came to interview me at Lancaster Prison, they had no documentation whatsoever of the case involving Bobby Taylor and Joseph King. The district attorney's office sent a representative to the board as they normally do. And as the guy started to read from the file, the record, they started to read off the 325 case, and I interrupted proceedings, and I told him, nicely, that, excuse me, sir, but I'm not here for that. That was a mistried case. And so he started to fumble around in the full folder looking for the controlling case regarding why he's there. And so all of a sudden he took a deep breath, closed the file, looked over at me on the rim of the top of his glasses. He said, "Well, I wondered why they had anything, put this in there anyway." And he said, "Well, you did do something, didn't you?" And I was like, "Huh?" "I'm going to show you a copy of the board discovery writ, and I'm going to read you his statement." The statement is found in the discovery motion that was part of my writ to the Superior Court, challenging the denial of parole. In that, this here states why I'm sending the writ to the court. And it reads, "The controlling case before the panel, and know that I'm filing this writ with no knowledge of what they did to me. So only thing I'm thinking is that they're making this big mistake in all of this, and I'm finding out that there's no documentation. And the only thing I know is I'm framed. I'm not knowing much about my co-defendant and his issues, because I wasn't even concerned about that during trial. I was only knowing that they were doing this to me." So some of what you're going to hear in this statement is a little twisted from how I understood it then. It says the controlling case before the panel for the petitioner's initial parole consideration hearing occurred on December 29, 1989. According to trial court testimony of prosecution witnesses, petitioner was arrested March 26, 1990 on a similar but unrelated charges. While awaiting trial on those charges, he was arrested and arraigned at Compton Municipal Court for the December shooting. These new charges were consolidated with his other case, which included a co-defendant, and tried by a jury. Petitioner was found guilty of the December 29, 1989 shooting and sentenced to consecutive life terms plus enhancements for great bodily injury and use of a gun. The probation officer who wrote his report mistakenly documented petitioner's commitment offense as the March 26, 1990 shooting, and a shooting that his co-defendant was convicted of. Aside from the probation officer's reports, there are no documents of reference in this case. I'm going to go down here and show you what I mean by that, because they really worked me over when you hear exactly what they were doing. In the instant case, discovery is crucial in order for petitioner to receive a fair adjudication of the constitutional deprivation claims he has raised in the federal petition. A major reason he was deprived of his liberty interest in parole is because the Board of Parole hearings, the petitioner, nor the court has basic documentation to determine what the facts are and what they aren't. The presiding commissioner read the probation officer's report into the record to establish the facts, but when the probation report was proved inaccurate, the commissioner said, "Okay, we'll not consider that." I was curious as to why it was in the probation officer's report. "But there were others that you were involved with, correct?" This is what he told me, and I was like, dang, what? When making its decision, the board relied upon these same findings as fact, denying parole for 2 years. Petitioner appealed this decision in Superior Court, who affirmed the board's decision. Petitioner, meaning me, request all documents related to the shooting of Bobby Taylor and Joe King on December 29, 1989, including A, the time of the shooting when it was reported to the police; B, the names and reports of the responding officers; C, any statement given by the parents of the victims who drove them to the hospital; D, the burger stand investigation and interviews. E. Documentation of injuries sustained by victims on 12/29/89. F. Police report by LAPD detectives Gary Aspinall. G. Photo lineups and signing statements shown to the victims. H. Date of Bobby Taylor's arrest for the charges which he appeared in court during the proceedings on. Toxicology reports taken by the victims that night. Gang files of me, then known as Thumper from 97th Street East Coast Crips. What were your gang files on me? I sent off for documentations to the. This right here is. See if you can see this in very bad condition. It was in the garage, but this is to the Los Angeles County District's Attorney's Office. The response again from the District Attorney's Office and from the Los Angeles Police Department. Now, let me show you how they got me going around in a circle and they're preventing any of this from coming out. The District Attorney tells me on February 20th, regarding public records request, he says, we have not yet located the file where the information you have requested is located. Then they send me a letter back a couple of weeks later telling me we are unable to locate the file related to your public records act request. I suggest that you contact the police agency that arrested you to see what you can obtain from them. When I write to the LAPD, the Los Angeles Police Department tells me the Los Angeles Police Department has reviewed your letter requesting witness information, original notes, all real evidence, records of felony convictions, and witness records. No results of any mental experimentations or exculpatory evidence statements pertaining to case number TA005544. It appears that you are attempting to obtain records in order to reopen / appeal your criminal conviction. Please be advised that all discovery efforts in criminal matters shall be made through the prosecution and or the courts. In addition, please be advised that after filing of a petition of habeas corpus, all discovery requests require permission by the court who's in collusion in which the petition has been filed. So I got to go back to Compton Court. Discovery materials cannot be provided without prior approval. All future requests must go by via the process of discovery and dictated by the court which the petition of habeas corpus was filed. Well, you know, the petition I filed was denied by the court. The only thing left after this was a bombshell. I didn't know that Bobby McClellan was also looking into the matters based upon what they did to him. And he filed a bombshell 97-page civil rights complaint to the internal affairs of the Los Angeles Police Department. This is everything that they did and how they did it. He didn't leave out nothing. All of it is exhibits and admissions from the courts and everything. And not even a month or two later, Linda Bushling, after I wrote her a letter, I wrote her a letter before Bobby sent this, and she wrote me back. It's on their itinerary, and you can check it. It's still there. She wrote me back, threatening me with more charges if I didn't stop writing it to her. He filed this, and she resigned and was disbarred. To this day, Linda Bushling has been disbarred quietly. She cannot practice law in California anymore, and they gave her $18,000 per month pension. She got paid $18,000 for doing what she did to us, and that was 2007. I went to the board in 2007, and I went all the way until 2014. They never informed us. They didn't let us go, no nothing. And to this day, she's still getting paid for what she did to us. So they all know what's going on. Compton Court, Los Angeles Police Department, and the District Attorney, they have a triangle going. And it's a scandal. And I'm quite sure many blacks and Latinos have been caught up in that net.